In Louisiana, the terms power of attorney, agent, and attorney in fact are not used in the civil code. Instead, the civilian terms are mandate, procuration, and mandatory. Although these documents are common, they're often misunderstood. This month, I'm breaking down the what, the who, and the why so you can make informed decisions that protect yourself and those you love. 1. Understanding the types of representation. Whether you call it a power of attorney or a mandate, it's ultimately about one person giving another authority to act for them. Representation may be granted by law, such as parental authority, or through a juridical act executed before a notary or attorney. Louisiana recognizes two primary forms. Procuration. A procuration is a unilateral written act that authorizes someone to perform a specific action for the principal. It is narrow in scope, often used for a single transaction or limited purpose. The representative is not bound until they accept or act under the document, at which point it may become a contract. A conditional procuration, also called a springing power of attorney, only takes effect when the principal becomes disabled. Under Louisiana law, the disability must be confirmed in writing by two Louisiana licensed physicians and witnessed by two people. General mandate, power of attorney. A mandate is a bilateral contract where the mandatory agrees to act for the principal. It provides broader authority, such as handling banking, property management, and other general affairs. Although a general mandate grants wide power, certain actions, donations, loans, endorsements, healthcare decisions, must be specifically stated in the document. Some acts, such as marriage or making a will, cannot be done through representation at all. General durable mandate, power of attorney. A durable mandate continues even if the principal becomes disabled or incapacitated. This form provides the greatest protection because it allows immediate action when needed, avoids delays, court orders, and guardianship, keeps finances and personal affairs stable. While mandates are generally durable under civil law, some institutions require durability to be explicitly stated, so check with your bank or financial institutions. 2. The roles, authority, and responsibilities. The principal is the person who grants the authority and maintains the right to make their own decisions as long as they are competent. Their responsibilities include choosing a trustworthy mandatory, clearly defining authority, executing the document properly, ideally with an experienced Louisiana notary, recording the mandate when required, revoking or modifying the mandate when needed. Any revocation or modification must also be recorded to be effective against third parties. The mandatory is appointed by the principal and must act in good faith, follow instructions and limits, manage affairs with care and prudence, keep the principal's property separate, maintain clear records. They may not act outside the authority given. If the mandate is silent on major acts, such as selling property or making gifts, they cannot perform them without express permission. A mandate ends upon the principal's death, except when the mandatory is already completing an authorized task. The mandatory is not allowed to act outside the authority they are granted. If the mandate is silent on a specific power, such as selling real estate or making gifts, the mandatory cannot perform those acts without explicit permission. The mandate automatically expires when the principal dies, unless the mandatory is already in the process of completing a task authorized by the mandate. If so, they are allowed to complete the task in full. Choosing the right mandatory. This person should be trustworthy, organized, and financially responsible, emotionally steady, comfortable making decisions. This is both a legal and personal responsibility. This is not just a legal role, it is a position of tremendous personal responsibility. 3. Reasons you may need a mandate. A mandate is a vital protection tool. Common reasons include medical or cognitive incapacity ensures someone you trust can manage your affairs. Estate and long-term planning prevents court intervention, business or real estate needs, allows someone to sign or handle time-sensitive tasks, travel, deployment, or extended absences, keeps obligations on track, Peace of mind, you control who acts for you and how final thoughts. Mandates and procurations are not just legal documents, they're instruments of protection, planning, and peace of mind. Whether you need a simple, limited procuration or a comprehensive, durable mandate, a knowledgeable Louisiana notary can help ensure your document supports your goals and complies with civil law.